thrilled to have you once again for session. And as you join us, please feel right at home. If you have a friend or colleague who you know registered for the session that hasn't joined the session, please tell them our session is on. We're streaming live on YouTube at East Africa Law Society and also live on Zoom. And so you can catch us on either of those platforms. Now, this afternoon, we discuss a very timely and crucial issue that is continuously growing. It's not a new phenomenon, but it's one that is constantly evolving, and that is the subject of adoption. Now, this afternoon, we'll be looking at perspectives on adoption, and we'll be discussing regional challenges and emerging opportunities. And now, as family law practitioners, we all know that adoption is not just a legal process, it's one of the most profound interventions that society can undertake to secure the future of its nurturing family environment for those who cannot grow up within their biological families. Yet, as we know, achieving involves navigating complex legal, ethical, and policy landscapes that span national and international frameworks. Now, across the adoption systems rapidly evolve as nations grapple with twin imperative, protecting vulnerability and ensuring access to permanent family presence. Now, we've also seen intercountry adoption, domestic reform, regulatory oversight, and judicial field, where legal practice meets human impact. Today, we have that unique opportunity to explore comparative in practical experience and forward-looking perspectives. And now, to guide us through this very critical dialogue, our colleague, Ms. Nadej Iriho Nsengimana. I don't know if I've massacred your name, but Nadej is a distinguished member of the Rwanda Bar Association and the East Africa Law Society. She currently serves right here in Arusha, Tanzania, the ES Secretariat as a legal assistant, and she's a recognized leader in child protection, family law, and she holds the prestigious International Academy of Family Lawyers Early Career Award 2025, and several top honors for her academic and professional excellence. Now, Nadej's alternative dispute resolution and for emergers. Now, today, Nadej will skillfully steer our discussion and bring her unique insight, energy, and deep commitment to child welfare and bring this discussion to a very wonderful close at the end of this. So, ladies and gentlemen, please join me in welcoming our moderator, Advocate Nadej, as we embark on this wonderful journey. Let's give a round of applause in the comment section by sharing an emoji as we welcome Nadej. Nadej, you're welcome. You have us for the next 2 hours. The floor is all yours, and it's a pleasure to.
Thank you so much, Gabriel, so much for that kind and very wonderful introduction. I truly appreciate. As it was mentioned by Gabriel, my name is Nsengiyumva Iriho, not Nsengimana, Nsengiyumva Iriho Nadej. I'm an advocate from Rwanda who's currently serving at the East Africa Law Society Secretariat here in Arusha, Tanzania. So today I'm so honored and very humbled to moderate this webinar with very incredible and brilliant legal minds on this on today's topic of perspectives on adoption, where we explore more about regional challenges and also emerging opportunities. But before we dive into the main discussion of today, I want us to brainstorm on just one question. How can adoption systems ensure that every adopted child finds not just a family to belong to, but a safe, ethical, and legally protected path to belonging? This question lies at the very, very heart of today's discussions, and I'm pretty sure that after this webinar, all of us will be answered. Like we will know like what like how can adoption systems ensure that every child finds not just a family to belong to, but a safe and also ethical and legally protected path to belonging? As we all know, adoption remains one of the most significant legal mechanisms through which societies to seek to ensure that children without parental care can grow up in stable and supportive family environments. As reflected in Article 3, Paragraph 1 of the United Nations Convention on the Rights of the Child, it states that the best interest of the child shall be a primary consideration in all actions concerning children, including adoption proceedings that we are going to talk about today. At the same time, adoption processes raise complex legal, ethical, and institutional questions, particularly regarding safeguards to protect children and ensure that their best interests remain paramount. Across Africa and globally, adoption systems are evolving in response to emerging challenges, including questions surrounding intercountry adoption, regulatory oversight, ethical practices, and judicial safeguards. So today's discussions brings together distinguished experts from the judiciary, legal practice, academia, and international family law, who will share insight on how adoption can be strengthened while ensuring the protection. So, distinguished participants and also colleagues who are joining us across the region and beyond, you're most welcome to today's webinar. I'm really sure that you're going to enjoy. So this important webinar was organized by the East Africa Law Society through its Family Law Committee in partnership with the IFL. That's why at this juncture, it's my pleasure to welcome one of our conveners, Patricia Mundia, who will give us a brief welcome remark. And for those who don't know Patricia Mundia, she's the chairperson of the ELS Family Law Committee, and also she's very, very visionary leader, and also she's very passionate about family law. So we are very, very honored to have Patricia in the room today. And over to you, Patricia. Thank you.
Thank you so much, Nadej, and also thank you to Gabriel for setting such a good introduction and background to our discussions today. I have this distinct honor and privilege, of course, together with so many of you who are present and so many, of course, who are part of the International Family Law associations. And I am grateful for that. And it is because of that association that we've had together that we have been able to make this possible. I think it's good to just give, by way of background to those who probably were not able to attend the conference last year, to let them know that IFL has been such a key partner with ELS, not just in the conference, but also with a student seminar that we held in September, a very successful seminar. And this, of course, was followed by an AGM that IFL had in Nairobi. And it is there that we also had the opportunity to discuss with them our conference in November. And we also had some fellows from the International Academy who attended and were panelists. And as a result of that, we thought it would be prudent to continue with the partnership because it is mutually beneficial. We are able to learn from each other's experience. And that is how we came up also with the idea of a series of webinars around family law topics. We hope to hold these webinars every month, particularly the second last or the last Thursday of every month, we can have a topic on that. Next month, I know we have one on surrogacy and assisted reproductive technology. We also will be having topics around even custody around the region and inviting speakers from the region. So we're looking forward to that. And today is the first of course, a series of many others that will run all the way to March 2027. So we are very excited about it. And we're also happy to see that we have a good list of attendees from what I see. And without further ado, because I only have 5 minutes, I don't want to take up time that the speakers will be using. I will introduce also my senior colleague and also fellow of the International Academy of Family Lawyers. Her name is Rachel Kelsey. She's the immediate former president of the IFL. She's also the first court and the only woman from the UK in the 39-year history of the Academy. She's the founding partner of SKO Family Law Specialists, which is the largest niche family practice in Scotland. She's the only star individual in Scotland in Chambers and Partners, and the only Scottish lawyer in Band 1 of the UK-wide High Net Worth Guide. She was the recipient of the Private Client Lawyer of the Year 2023 award at the Legal 500 Scottish Law Awards, and this was from a short list of 10 lawyers, including tax, rural property, and family law specialists. Rachel currently sits in the Family Law Committee of the Scottish Civil Justice Council, having been appointed by the Lord President to sit for a third term, and is the only Scot to sit on the UK Ministry of Justice International Family Law Committee. She splits her time, Rachel, and thank you. She's my co-convener today.
Thank you, Patricia, and I am also Patricia's biggest fan. So we have got to know one another in recent years, and it has been a huge joy for us as an organisation to develop a relationship with the EALS, and we very much consider ourselves to be honoured to co-partner with you on this and some of the other work that Patricia has mentioned there. You certainly don't need to hear any more about me. I'm very grateful to Patricia for being quite so kind about me there. What I am going to do is spend 2 minutes talking a little bit about the IFL, the International Academy of Family Lawyers, because we are very keen not only to develop and enhance the relationship that we have with the EALS, but also to provide you as individuals with, we hope, opportunities for this kind of useful education, but also to develop a relationship with us in your different jurisdictions. The IAFL, we are in our 40th year now, and we currently have 39 fellows from 11 different jurisdictions in Africa. One of our key areas that we have been working on for the last decade or so is the institution of an African chapter. At the moment, we have 4 geographic chapters around the world, and it is long overdue that we have an African chapter in order that we can ensure that the clients that we work with are able to access the best possible legal advice in their individual relevant jurisdictions, but also so that we can support the resilience and the practice of family law as a specialism across our jurisdictions. Many of us come from smaller jurisdictions where there are real challenges around resourcing for the civil justice system. And those of us who practice family law are very much committed in this organisation to elevating the practice of family law so that it is properly recognised as such a crucial part of our societal cohesion and a part of our civil justice system. So we are very much looking forward to continuing with the relationship that we have with you. We are very much, many of us are looking forward to coming to Zanzibar later in the year, and we'll look forward to breaking bread with you, spending time with you, and learning from you. And it is a privilege for us now to be involved in some small way and to learn from you in this important session in relation to adoption. I'm going to hand over now to your first speaker for this panel, who is Gemma Daly, who is a family lawyer in London, and she's going to give an international perspective on the issues that we'll be looking at today in this session. before we will then drill down into the issues that arise in some of your jurisdictions in East Africa. So Gemma, for those of us in the UK, needs very little introduction. She is considered as one of the preeminent child law lawyers in the UK, and in particular in relation to issues around adoption, surrogacy, and parenthood in general. She has been involved with, and indeed the driving force behind, many of the seminal cases in the last 2 decades that deal with the recognition of international or recognition of adoption orders from out with the UK, and indeed the revocation of adoption orders. I am going to simply read what our leading family judge in the area of parentage has said about Gemma as the introduction to a book that Gemma and her colleague Catherine Cronin co-authored that was published in December 2024. This is a book entitled Child Migration, Family and Immigration Laws, and was published by Bloomsbury, as I say, just over a year ago. Gemma did the family law elements, and Catherine Cronin, who is a very senior barrister in London who dealt with she is an immigration lawyer, dealt with the immigration elements. So the foreword to the book was written by Mrs. Justice Tice, in which she said about Gemma, together with Gemma Daly, Catherine Cronin, they have jointly taken the reader through the wide field of child migration before turning to consider immigration law in the context of inter-country adoption, kafala, and international surrogacy arrangements. These chapters benefit from the real-life practical experience both Catherine Cronin and Gemma Daly have had in advising and being instructed in many of the leading family cases, where the clarity they have each provided regarding the relevant immigration status of the parties and the children and the family law elements have played such an integral part in the outcome in these cases. So you are about to have the privilege and pleasure of listening to Gemma, who will give you some of the international perspective of these issues. And thank you all for having me. It is a great joy, and I'm very much looking forward to hearing from those of you who are speaking about the position in your individual jurisdictions. I will hand over now to Gemma. Thank you.
Thank you, Rachel. And good afternoon, everyone. I'm absolutely honoured to be a part of this panel discussion today to discuss these really important topics. So I'm going to talk to you today about how we are dealing with adoptions of African children in the UK courts. I'm going to highlight some of the problems that we are navigating and what the solutions might be. So as Rachel has said, I've been practicing in the area of intercountry adoption now for more than 20 years. Over my practice period, I have seen a number of changes in the law relating to the regulation of intercountry adoptions, and I've watched the trends change significantly from a dramatic surge in numbers of adoptions from Africa between 2003 and 2010. I think there was something like a 3-fold increase following the high-profile adoptions by celebrities such as Madonna and Angelina Jolie, to a very sharp decline in international adoptions globally in recent years, and now with the increase in surrogacies. So despite this decline in inter-country adoptions, what we are seeing in England and Wales is a significant rise in the number of families who are living and working in the UK who are adopting children domestically from African countries who are not signatories to the 93 Adoption Convention. So before 2014's, adoptions from Africa were relatively straightforward. They didn't attract much attention in our courts, and that was because there was a large number of African countries whose adoptions were automatically recognised as valid and lawful adoptions in the UK, without adoptive parents having to take any steps at all. However, on the 1st of January 2014, the law changed so that only adoptions from countries who had ratified the 93 Adoption Convention would automatically be recognised as adoptions in England and Wales. So there has been a shift in how we are dealing with these cases and the attention on those cases. Sorry, I'm at home and someone's just knocked my door. Apologies. Now, for those African countries that are not a signatory to the 93 Adoption Convention, and where African parents have brought or are seeking to bring a child they've adopted, typically from their home country, into the UK, the High Court allows for applications for recognition of domestic African adoption orders under the inherent jurisdiction, this being the only route available for adoption orders from non-convention countries. So the purpose of these applications really is twofold. So firstly, it's to establish the recognition of the legally created parent and child relationship under English law. And then additionally, these orders assist to satisfy our immigration rule requirements and British nationality policy objectives for the settlement and for the citizenship registration of adopted children, which requires that their adoptions are recognised in UK law. So the facts of these cases follow a very similar path. The applicant adoptive parents from an African country are living and working in the UK. They're unable to have their own children, and they've made a decision to adopt a child. Most parents look to their home country to adopt because they want a child that will share the same identity and culture as them. Some also look to their home country for ease. Applying in their home country for a domestic adoption is a much quicker option, an easier option for them than having to comply with the international safeguards, strictures, and assessments. But how do we ensure that children's interests are protected in this scenario? So thinking about those children, they're usually children who are abandoned and who are living in orphanages. The adoption order will be made in the child's home country, but after adoption, it is only at this point that parents will realise that they can't return to the UK with their child. They're stuck. In the home country, the child has to remain, whilst adopters have to return back to the UK to work, separated because of our immigration law, which prevents the entry of a child whose adoption is not recognised. These parents can't apply for a readoption in England because they can't meet the assessment criteria. They can't travel to England. The child can't be seen by the relevant social work authorities. And often they can't apply for a non-Hague Convention inter-country adoption or either because they are temporarily settled and working in the UK without indefinite leave to remain. So the only option for these parents in our jurisdiction is a recognition application, which needs to be made in England, whilst arrangements have to be made for the care of the child in their home country, either by relatives, by family friends, or sometimes I've seen cases where parents have to arrange for staff to look after children while they go through our processes. So how does the English court deal with these applications to ensure that children are appropriately safeguarded? The criteria for recognition was established in 1956, a long time ago, in a case called Re Valentine Settlement. Now, I have been involved in almost all of these cases. Sorry, sorry, bear with me one moment, guys.
I heard Gemma's dog in the background there. It is a beautiful dog, but he is a bit of a cheeky dog and clearly clearly hasn't made. I'm just saying, is that Sid?
It's not. I'm so sorry. It's another dog that I'm looking after, and she's like really temperamental. I'm so sorry about that. So just going back to where
everybody on their toes, they're awake. Exactly.
I've been involved in almost all of these cases of recognition of African children. And actually, despite my best efforts to sort of expand the criteria to assist families moving globally, I have not been able to do so. The criteria remains very strict and it hasn't changed since 1956. So recognition will only be granted if the adoptive parents are domiciled in the foreign country at the time of the foreign adoption. The child has been legally adopted in accordance with the requirements of foreign law. The foreign adoption must in substance have the same essential characteristics of an English adoption. So what that means is it must create a valid legal parent-child relationship and extinguish the legal relationship that the child has with their birth family. And there must be no reason in public policy for refusing recognition. Now, the more of these cases that have come before our courts since 2014, the more worried our government has become. And now, in these African cases, our government will intervene and will challenge the assertions that are made by applicant adoptive parents to scrutinise the adoption process in the home jurisdiction. Now, typically, scrutiny is focused on the issues of domicile and the validity of the adoption process. And our government is rigorously challenging the adoption process in the home country, relying on unreliable adoption paperwork. So, for example, we had a case which is called Re V, where the Secretary of State drew the court's attention to a letter from a professional at the Ministry of Women's Affairs and Social Development in Nigeria, which purported to indicate that the applicants and the child were domiciled in the UK. The Secretary of State sought to rely on that for the court to refuse recognition, but this is an issue with the use of the word domicile, and what the African ministry meant was that they were living, habitually resident in the United Kingdom. But the real issue here is the weakness in the checks that are completed by the authorities in relation to adoption applications from adopters who are living in the UK and other jurisdictions. And therefore, it's obvious these adoptions are likely to be inter-country adoptions, which are not complying with the international strictures. In other cases, our government has challenged the legality of the adoption process, asserting that the adoption order made in the home country was made unlawfully. So suggesting that the adopters did not meet the laws of that country with regards to, in particular, residence requirements before the application was made to the court, and the living together period of time not being met, asserting either that applicants had misled the court in the home country, or that these statutory periods were not complied with, but the courts in African jurisdictions are just turning a blind eye to it. And the problem that we have when these applications come before our court is that the paperwork from the courts in these home jurisdictions gives very little information to us about the critical issues for our court and our government, such as, for example, who was present at the court hearing, whether the court considered issues of the birth parent's consent, the basis on which the court order was made, whether it did consider elements of the statutory scheme that weren't met, and if so, were those elements waived, and if so, on what basis, etc. We simply don't have the paperwork that the court needs. These cases, therefore, require us to provide expert evidence from practitioners in the home country. So that's why these things, collaborations, are really important to us, because we need experts in the field of adoption to examine and confirm whether the order was validly made, lawfully made. And so we need to work together, we need to collaborate, and we need to find the best people to present the evidence to our courts. So this focus on Africa, for us, has brought not with it just the benefit for children of finding families, but has brought to the forefront of our minds the introduction of illicit practices and abuses such as abduction, child trafficking, and the sale of children. And it's the government's intervention in these African cases which has led to the 2021 suspension of all adoptions from Nigeria because of these difficulties confirming the background and the adoptability of children, because of the unreliable documentation that comes before our courts, because of concerns about corruption in the system, evidence of child trafficking, and concerns, as I've already said, about adopters who are habitually resident in the United Kingdom, but not following these inter-country processes. These issues are not just limited to Nigeria. There is an urgent need to effectively regulate inter-country adoptions in Africa. It's not an abstract legal issue requiring a politically correct debate without global action. This is a critical issue involving the lives of really vulnerable children and the protection of their best interests where an inter-country adoption takes place. Also, the protection and rights of biological parents and the adoptive parents. I'm going to talk to you now about the 93 Hague Convention, because this is the most comprehensive international instrument on inter-country adoption and would have the most significant positive implications in this regard. So the purpose of the convention is to address the concerns that have been identified by our courts and our governments in respect of adoptions from African jurisdictions. It lays down safeguards that guarantee that the best interest of the child and the protection of his or her fundamental rights where an inter-country adoption takes place. And it is there to prevent the abduction, the sale of, or trafficking of children through a system of inter-country cooperation. So why is it so important that African states accede to the 93 Hague Adoption Convention? Accession to the convention will promote and uphold the best interests of the child in the context of inter-country adoption, as I have said, through cooperation between the state of origin throughout the entire adoption process. Article 4 of the convention sets out the principle that the competent authority of the state of origin is required to establish that in accordance of the law of the state of origin, the child is adoptable. that adoption is in the child's best interests, that the birth parents have been counselled and the effects is known of their consent to the child to be adopted. They know, they understand what they're signing, that the consent is given freely and is not occasioned by payment or any compensation. And taking into account the age of the child, that the child too has been counselled and has given their consent and has had their wishes and feelings taken into account. Article 5 of the Convention addresses the eligibility and the suitability of prospective adopters. States are required to confirm that adoptive parents are eligible and suitable to adopt, that they have had access to that counselling, and really importantly, that it has been determined that the child is or will be able to enter and reside permanently in the receiving state, so that children are not left stranded after adoptions, as we see at the moment, but can remain in the care of their adoptive parents. The Convention also contains provisions concerning other really critical aspects of inter-country adoption procedures, such as the requirement for a comprehensive report on the adopters, the safeguarding checks on the adopters, the requirement for a comprehensive report on the child to ensure that an inter-country adoption is the right option for the child and that other options have been explored to see whether it is possible for the child to remain within the birth family or birth country, and to ensure that authorities are alert to issues such as informed consent, background, and improper financial gain. Once an adoption has been completed under the Convention, the state of origin issues a certificate called an Article 23 certificate, which operates to confirm that the adoption should be recognised by operation of law in all other contracting states. So you can take your child and your certificate to any contracting Hague Convention country where you will be the parents of that child, and that is recognised automatically. So without accession to the Convention, the only remedy available to children in the UK is through this recognition according to common law. But the more of these cases we have, the more they serve to highlight not only the problems with the procedures in the state of origin, but also the very real difficulty and uncertainty for families and children completing non-convention adoptions, where obtaining the adoption order should be the end for them, but it's actually just the first step, because without a recognised adoption, children are separated from their families, sometimes for many years, while they go through, first of all, the unsuccessful immigration application. They can't travel, but they realise for the first time their order is not recognised. Then they have to go through court proceedings in England, which is costly and lengthy, particularly in this climate where we know our government is going to intervene to challenge this. And then finally, further immigration procedures before they can secure the child's entry to the UK. So the benefits to children and families of the 93 Convention are far-reaching. First of all, it gives effect to Articles 3 and 21 of the UNCRC that provides that the best interests of the child should be the paramount consideration in adoption. Secondly, it creates this cooperation framework from beginning to end that I've talked about, establishes the minimum safeguards that promotes mutual trust and cooperation. And finally, it reduces the emotional distress, the expense, the delays, and the uncertainty faced by all of those concerned. Without accession to the Convention, it's placing African children in positions of further uncertainty and further vulnerability, which cannot serve to protect their best interests and which could have been avoided. Thank you. And apologies for the dog.
Thank you so much, Gemma. Thank you so much for your insight. Thank you for highlighting the international perspectives. And thank you so much for your legal experiences and everything. We truly appreciate. Thank you so much. And thank you so much to IFA and Rachel as well. For those who are interested, I think they can visit your social media platform, IFA social media platforms. They have a website. It's International Academy of Family Lawyers. You can Google it, or I will put the link in chat box. And participants, anyone who has a question or any contribution, kindly submit it in the chat box. We will address them during the interactive session. Yes. So allow me to welcome our second speaker, Dr. Harriet Diana Musoke, who will talk about protecting children in adoption systems. She will talk more about ethics, safeguards, and also the role of the legal profession. So before I give her the floor, allow me to read her bio. Dr. Harriet Diana Musoke, Senior Counsel, is a highly respected legal practitioner and academic with decades of experience. Dr. Musoke holds a Doctor of Juridical Science from Emory University, USA, a Master of Laws with distinction from Georgetown University, USA, a postgraduate diploma in legal practice from the Law Development Center in Kampala, and a Bachelor of Laws with honors from Makerere University, and she was awarded the prestigious rank of Senior Counsel in 2019. She has been an advocate of the Court of Judicature of Uganda since 1985 and currently serves as a senior lecturer and PhD program coordinator at the Islamic University in Uganda. Over the years, she has held several prominent leadership positions, including president of the Uganda Law Society between 1998 and 2000. She was the chairperson and secretary of FIDA Uganda, commissioner at the Uganda Law Reform Commission, and board member of the Uganda Registration Services Bureau. Her work focuses on family law, women's rights, children's rights, and international human rights, and she has contributed extensively through research and publications in these areas. We are truly honored to have her with us today. So the floor is yours, Dr. Diana Harriet Musoke, and allow me to give her a round of applause as well as we welcome her.
Hello.
Hello.
Can you
Hello.
hear me?
Yes, we can.
Okay. Good afternoon, everybody. And I'm sorry, where I am, the weather is not very good. So the network may not be very good, but I hope I'll be able to present what I'm supposed to present. Thank you very much, the East Africa Law Society, for preparing and arranging this webinar, and on such a very important topic that we are looking at on the issues of adoption, and more especially inter-country adoption, which is really something that is at the heart of looking at the best interests of the children. Now, my topic is to discuss about the ethical perspectives of advocates, lawyers, when we are dealing with adoption matters. Now, in Uganda, under the Children Act, we have provides for adoption, and we have the inter-country adoption, where we have citizens adopting children, and then we also have inter-country adoption, where we have non-Ugandans adopting children. Now, we have a number of conditions that the adoptive parents, the prospective adoptive parents must adhere to. One of them, well, of course, they must be adults, and the age is 21 years and 25 years, or 25, the adoptive parent must be 25 years and must be 21 years older than the child that they are trying to adopt. And they must be persons of sound mind. They must have a job, financial aspect, because you can't take on a child when you cannot be able to look after that child. And if the parties are adopting as a couple, then you must get the consent of the spouse, and also the consent of the biological parents is a must, unless if those parents cannot be found. And if they cannot be found, then you have to apply to the court for the court to dispense with the consent. And we all know that that consent is very important because of the effect that the adoption order has, where the legal ties of the biological parents is completely severed, and then the adoptive parents take on all the legal ties of the child. So that's why the consent is very important. And this consent should be written consent. There's also the requirement that if the child to be adopted is above 14 years, then that child should also give their consent, unless if that child cannot be able to give the consent. And except in exceptional circumstances, a single male cannot adopt a female, and a single female cannot adopt a male. And of course, that is for obvious reasons, because of the fear that you may bring up this child, and then eventually, when the child is old enough, then the adoptive parent may want to maybe marry or have a sexual relation with the child. So except in exceptional circumstance, that is when they can allow a single male to adopt a female. And we've had one such incident, and it was the case of Rina Sazi, where a male was allowed to adopt this female. And the reason was because this girl was so physically disabled that nobody would be able to take her on, and yet this person had been with this child for some time. Now, there's also another condition in that the adoptive parent must have fostered the child for at least 1 year, that is 12 months, to be in their custody and be able to know the child that they are going to take on, whether they will be able to look after this child. And this fostering and supervision is under the supervision of a probation and social welfare officer, who at the end of the day has to write a report to show whether the parents are actually fit and that they can be able to adopt the children. Now, when it gets to intercountry adoption, more conditions are imposed by the law. And one of them is that the country of the intending adoptive parent must write and confirm that they are going to accept the adoption order. Because if they are not going to accept the adoption order, then the court cannot give the adoption, because remember, if it is an intercountry, once the adoption order is given, then the adoptive parent will take the child to the country where they live. And if that country is not going to honor that adoption order from Uganda, then it will be difficult. That child will end up being stateless. Now, it is also important that the intending adoptive parent must also get a report from their social welfare officers to show that actually this person has a home and has a place where they are going to be able to put this child. Because it doesn't make sense for the child to be taken away from the biological parents and taken to the adoptive parents, and yet they have nowhere to stay and they cannot be able to look after this child. And the intending adoptive parent also have to show their financial, capability. And this is where there's need to have at least a letter to show where the adoptive parent works, or their bank financial statements to show that actually they do have money in the country where they are. Now, as lawyers, when we are dealing with these issues, and there was a time when we had so many intercountry adoptions. Now, when you look at the record, most of these intercountry adoptions were taken from children who were actually living in approved homes, in that either their parents were unknown or the parents were known, but they were not looking after these children, and the children had been committed to the approved homes, and they were under the care of the wardens of those homes. And at the end of the day, it was the care order that was given for these children to be in the adoptive homes. The wardens were the one to give the consent for the children to be adopted. Now, as lawyers, what are the ethical issues that we really need to have in mind when we are dealing with issues concerning children? One of them is that we as lawyers must make sure that the kind of consent that is given by the biological parents or by the wardens who are where the children are in the care of, that consent is informed consent. We all remember a case in Uganda where a parent was informed that these Americans are taking your child, and for her, she thought that they were going only to pay the education expenses and the medical expenses of the child. She gave her consent, and then after 1 year, she said, is it possible for my child to come back and see me? Because I really miss my child. And the adoptive parent said, this child is now mine. This child is no longer yours. So what are you saying? That you want the child to come back and see you? And that is when it dawned on the lady that actually she was not properly informed that this child is completely, she won't have any authority over this child, that the child has been taken over by the adoptive parents. And it was something that came up in the news for a very long time, and they were saying that maybe the lawyer who informed this lady did not give her informed consent. So as lawyers, it is very important that when we are dealing with the biological parents, if you're acting for the biological parents, or if you're acting for the adoptive parents, then you need to give them the necessary information that will be able to make them give an informed consent. Now, and when we are dealing with these issues also as lawyers, the conflict of interest. Where does the conflict of interest come from? Many a times those who come from the non-citizens who come to adopt, they'll come to us as lawyers. We are going to start acting for them. And then as we are acting on their behalf, we then also start acting on behalf of the biological parents. Now, that is very wrong. Why? Because then it is going to compromise us in that we are going to have a conflict of interest in that the non-citizen or the adoptive parent is going to pay us very highly. Then the biological parent, maybe they don't even have the money. That's why they are giving away their child. And then eventually we are going to act for the adoptive parent, and we are not going to have interest of the child at heart. What will we looking at? I need to earn my fees. And when you start looking at, I must earn my fees, it means then you are going to be compromised and you are going to get into issues where you are not going to give the necessary information to the parents. When we are, as lawyers, when we are dealing with issues of adoption, let's look at the emotional complications, the complexities that may come up. You see this parent, you know as a lawyer that this parent, who as she is going to lose the child. To you, what you are doing is you are pushing that this the non-citizen, the adoptive parent, wants the child, and you are going to do everything under the sun to make sure that the adoptive parent gets the child. And then at the end of the day, we completely lose ourselves. We completely detach ourselves from the emotional aspects that the biological parent is going to go through, which as lawyers, we really have to work on, because if not, then we are going to lose. And remember, when we are dealing with issues of adoption, the best interest of the child is what is important. Now, as lawyers, it is our duty to protect the biological parent. Why? This child who is going to be adopted is a citizen of your country. We should be able to protect our citizens in that as much as we want them to have the best of life, but we need to know at the back of our minds that the issue of trafficking in children for purposes of sexual exploitation, for purposes of organ harvesting, is at the increase. It's at the rise. So as we are looking at the adoption, especially the inter-country adoption, where we are not going to be able, once the child is adopted and taken outside the jurisdiction of the Ugandan courts, it is going to be very difficult to follow up, because what happens later is left to the adoptive parent. And maybe when the adoptive parent is coming in to adopt the child, maybe what they have in mind is maybe not to adopt the child for purposes of furthering the best interests of the child, but maybe it may be for an ulterior motive. So that is something as lawyers we really have to consider, because it is very important to protect the biological parents. Not only that, as we are looking at issues of adoption, we need to look at the best interests of the child. Is the child being taken from one cultural aspect to another cultural aspect? Is it good for the child? Will that child, as the child is growing up with a very dark skin and living in this environment where everybody's skin is light, and I'm not saying it out of not wanting the children to be able to be adopted, but we are looking at it from the principles that are applicable to children matters. That very important principle of the right to life, survival, and development. When this child is developing, are we really looking at having this child, having the inter-country adoption? Is it in the best interest of the child? Should that be number one that should be done? Now, another aspect that as lawyers, our duty, we should never represent both the biological parent and the adoptive parent. Surely, there is no way we can be able to have the interests of both at hand, because we know that as soon as we are looking at the adoptive parent, what are we looking at? The adoptive parent must take this child because we come up and say it is in the best interest of the child. But remember, we have been paid in dollars, or we have been paid in pounds, or even in shillings, and it's quite a good amount of money, and we really want to have these people take on the child. There are some cases where the judicial officer went ahead to even rule in relation to the requirement for fostering the child. And the judicial officer said that you can have constructive fostering, where the adoptive parent lives in Texas, gives powers of attorney to their lawyer to foster the child on their behalf. And then afterwards, they just come into the country, fly in the evening. Tomorrow morning, they're in court, and then in the evening, they take a flight and go back. Now, surely, that adoptive parent who has not even been able to stay with the child, how can they know that they're actually taking on to be with the child permanently? Because we all know the effect of an adoption order when it severs the ties of the biological parents, and the legal parents take over in all aspects of the child's life. Now, the issue of constructive fostering, and lawyers would stand up in court that I have constructively fostered the child, when in actual sense, the lawyer has not even been living with the child. The child is with the biological parent. Maybe the lawyer is giving them some money here and there. Then the lawyer talks to the probation officer. Then the probation officer says, I have been supervising this child, and moreover supervising the lawyer, because they're not supervising the adoptive parent. And then the report comes up, and then the judicial officer gives in this order and says, yes, the adoptive parent is suitable to be able to foster the child, which I think is something that is unfortunate. And at the end of the day, those are the cases where we had in that when the children were taken over, then there were issues that they were taken for sexual exploitation, and then they were taken for organ harvesting, and then the whole issue of inter-country adoption got messed up. Now, of course, there are some genuine cases which were really okay for the child. Maybe the child's parents, they were lost in during HIV/AIDS, and maybe the grandparents who were looking after the children, they did not have the money to look after them, and genuinely they wanted the interests of the child to be catered for. So we have those kind of cases. But then when we go to the issue of constructive fostering, then that is when issues came up. And also when we, the lawyers, we were trapped in that parents came up and said they did not give them enough information for them to make an informed consent. That is when the issues of us as lawyers came up. So it is very important, ladies and gentlemen, especially the lawyers who are involved in adoption matters, especially in inter-country adoption, that we take all the necessary precautions to ensure that actually the adoptive parents really do have the interests of the children at heart. With the amendment of the Children Act and the introduction of the National Children Authority, at least there is currently now a number of checks to ensure that actually the adoptive parents really want to adopt the children, because there is a panel which they refer to as the alternative care panel. Now that panel will sit down once a prospective adoptive parent wants to actually adopt the child. They will sit down and they are going to look at the papers, study the papers, do the necessary due diligence with the country where the child is going, or the adoptive parents live, to ensure that actually the documents that have been presented, that actually they are genuine documents. Because sometimes even these adoptive parents, they just go to their country and they get these forms, and once they bring the forms, we think that actually the forms are really genuine because they have a stamp, and we don't get into getting the courts have not been going to an extra mile to check with the embassies, to check with the consulars, to see if actually those documents were genuine. So now we believe that with the introduction of that alternative care panel, which scrutinizes the documents, and then eventually they make recommendations, maybe that is going to help the judicial officers that are dealing with inter-country adoption, so that they can be able to make a decision when actually the child that is being taken, it is actually in the best interest of the child, but not for purposes of doing maybe exploitation or anything else. Now, what would we look at in Uganda to see that we actually look at the adoption? I think adoption is good because is my time up? Hello, is my time up? Hello, is my time up?
Yes, just we have like 3 minutes.
Okay, yeah. Just to say that I think what we need to do now that we have the alternative care panel, which really scrutinizes the papers, I just call upon my fellow colleagues, the lawyers. When we are looking at the adoption, yes, we need the fees, but I think let us look at the best interest of the child. That should be the most important, so that when these children, our fellow citizens, when they go out there and they are taken to a foreign country, they are able to be considered. And maybe also to call upon our courts that when they issue such an order, they should accompany it in that when an order is given, the adoptive parent should be able to file a report with our embassies or our consulars in their countries, and we get to know, yes, it is their child, but that child was once a citizen of our country, Uganda, and they are able to know and follow them up and see what is done. And also to call upon my fellow colleagues that please let us try as much as possible to desist from acting for both the biological parent and the adoptive parent, because the conflict of interest is really going to work on our emotions eventually when we find that when we did the adoption, the child was actually mistreated wherever the child was taken. Thank you very much. There is more to discuss, and we'll discuss that later. But that's what I have for you. Thank you very much, and over to you, moderator. Thank you.
Thank you very much, Dr. Musoke. Thank you so much for those insightful reflections. Guys, kindly let us give her a round of applause. I want to see the emojis in the chat box. Thank you so much, Senior Counsel. Your presentation clearly highlights the important role that legal professionals play in ensuring ethical adoption practices and safeguarding the rights and welfare of children. So this brings us to the role of judiciary, ensuring that these principles are upheld in practice. So allow me at this juncture and allow me to welcome Honorable Lady Justice Mumbuwa Teresa Mateka, just to share with us the judicial role in safeguarding the best interest of the child in adoption proceedings. Before I give her the floor, let me read her profile as well. Honorable Lady Justice Teresa Mateka joined the judiciary in 1993 as a district magistrate and has steadily risen through the ranks to chief magistrate before her appointment to the High Court in 2016. Throughout her career, she has served in several stations across Kenya, including Kakamega, Butari, Nakuru, Nyahururu, Kibera, the Judiciary Training Institute, Nanyuki, Mombasa, hopefully I'm reading them right, Mombasa, Nyeri, and Makueni. So she's particularly recognized for her notable service as a children magistrate, demonstrating a strong commitment to child justice. She's a member of the International Association of Women Judges and the International Association of Family Lawyers, reflecting her active engagement in advancing justice both regionally and internationally. So we are truly honored to have her with us today. Honorable Lady Justice Mateka, you are most welcome. The floor is yours. Thank you.
Thank you very much for that very nice introduction. And I want to appreciate the previous speakers because I think they have addressed some of the issues that I had in my head and that I was going to speak to. It's a great honor to sit here and talk to fellow legal minds on this particular issue. And I'll just be talking about the Kenyan situation, maybe touch a bit on international adoptions. When I think about adoption and the role of the judge in Kenya, it has to start with our constitution and the rights of the child, especially Article 53 on the rights of the child. And those rights include the right to a nationality, the right to family, and very importantly, our Article 45 that recognizes the family as the place where a child can grow up in a natural, the natural fundamental unit of society, and thus the place where a child who may not have a family would be able to get one. So we have to start by asking ourselves then, when a court is dealing with an adoption, what is the first thing that, myself as a judge, what is the first thing? I want to know the child. And you will be aware that in our country that only the High Court has the jurisdiction to deal with adoption proceedings. But I can tell you it does not start there. It starts in the Children's Court. Because in our law, we have a provision of the law, Section 144, that gives us a criteria of children who are in need of care and protection. These are the children who may end up in an institution where they may end up being put up for adoption. And this criteria has about 36 of them, and it ranges from a child who is an orphan, a child who is a victim of abuse, a child who is neglected by her parents, a child with disability, a child with terminal illness, a child whose parent is terminally ill, a child who may be in conflict with the law, or a child who is even lost. You know, all those categories are the children who may end up in an institution. And Section 145 speaks to how the children's court will deal with that particular issue. One of them is to put them in an institution up to the time they turn 18 years, in periodic times of 3 years. And then they may end up in alternative care as provided for by our law. And more importantly, now the most important part is that any court that is thinking about alternative care at that level must, in the first instance, place the child in family-based alternative care. Now, so therefore, it's important for us to remember that that's where it begins, because that will take us to what other things the court that is dealing with the adoption matter might need to look at. Alternative care is defined by the Act as the arrangement made by arrangements made whereby a child is looked after outside the parental home under the provisions of this law. And then, interestingly, in our same Children's Act, alternative care is actually seen as a way of accessing the right to social security. Because it says every child whose parent or guardian is unable to maintain the child has the right to social security as guaranteed by our Constitution. And then it says, without prejudice to the generality of that section, social security includes alternative care services provided under this Act. And then it goes on to list the forms of alternative care, which now include adoption. And out of that, there's kinship, guardianship, foster care, adoption, kafala, and the rest. So you see that adoption actually is a very special way of taking care of children who may not be able to have parental care, and also to ensure that they have social security. If you think about that as a whole, if you envisage that, you can see the weight that's placed on a judge who is handling an adoption proceeding. And then the law goes on to us to tell us the objectives of that alternative care. So I have to always keep in mind and ask, why am I doing this? Why am I doing this particular thing? And the objectives are provided there for me. The first thing is to ensure the child gets parental care and protection that is in their best interests and for their well-being. So as I look at the application, that must be in my mind. And then to keep the child as close as possible to their usual place of residence. Remember, family care, and and then there must be some stability. Are we able to, and then I must ask, am I able to actually ensure that there'll be love and protection? Because in adoption proceedings, you are making that assumption. This child who has come from this difficult background will actually be in a loving home. The parents will love them and provide them a permanent home forever, you know, because no child expects that this family that has taken me at some point will turn around and say, you are not ours. And then, of course, a family that will safeguard the child from abuse, violence, and exploitation. Those are principles that must be at the back of my mind. So therefore, the requirement is that I must be able to follow that all the time and also ensure that the process is participatory. How? You see, my previous presenter talked about consent and the consent of the child, the consent of the family. That participation is not just provided there as a by the way. It is an important part of the process that the people who are required to participate in the manner the law has required them to participate have done so. And then there's a very big rider here that I think a lot of times we ignore. It says, if a child is being adopted, we must remember, are we removing a child from a family? Remember, when we are doing adoption, we might have to find out whether this child has other family members who can take care of that child. So if we are going to remove this child from all that, why are we doing that? Why this particular movement from this particular place to become the child of a new set of parents? And the law says it cannot be because of poverty or disability or education. You know, it cannot be the main reason that we are putting out a child for adoption. And then, of course, the issue of siblings. If children are related to one another, that the court must be aware that we must keep siblings together. So the law gives that guidance. Now, when you think about adoption, it's a process. Adoption is a process through which a child will become permanently placed with a legal parent or parents. And it is the adoption order that I'll make at the end of the day that will vest the parental rights and responsibilities relating to a child in the adopter. That's how our law refers to adoptive parents. And that adopter is a person in whose favor I'll make that order. So these are things must be at the back of my mind. It is important also because there are certain requirements that certain adoptions can only be done by relatives, that I also understand who a relative is. And again, the law defines who that relative will be. So therefore, in the adoption process, there are those fundamental things that the court must look at. I've already just spoken about a few of them, but there are those fundamental things that I must look at. So as a judge, I think I've just laid down basically the things I need to look at. In our country, it starts with an originating summons, but before that, there is an adoption agency that does a background check on the adoptive parents. And then there are reports that are supposed to be done by social services. So there are all these people who come together to prepare the document that comes before the court for the court to be able to make those proceedings, to carry out those proceedings. So for me, it is to ensure that that application complies with the law. The High Court has to look at the legality of that application, confirm that the application checks out all the statutory requirements. Then verify the identity of the adoptive parents. These people who are saying they are going to adopt the child are all the documents that are required by the law in the file. And then whether the reports that have been presented by the Children's Services and the adoption agency confirm that they are suitable. And then now we must begin to evaluate during the hearing, because a hearing proceeds before the court, for the court now to assess these applicants and also assess whether they have bonded with the child. So in doing all that, at the end, then the court will make the order. Now, some of the law has put in place some of the, I would say, conditions that adoptive parents must meet for the best interests of the child. For example, I have had the issue, the concern with intercountry adoptions and foreign adoptions. In fact, our law clearly says that the court shall not make an adoption order in favor of an applicant if any of them are foreign, unless it's a biological relative of the child. Of course, there are cases that have been litigated that have interpreted these provisions. There's also cases that have come before the court that have interpreted the provisions regarding what the challenges that come with intercountry adoptions in Kenya because of the moratorium that we had put before the courts, by the executive on intercountry or foreign adoptions. And it is important for us to look at that in relation, that moratorium, those provisions, together with what the law says. Our Children Act requires that any person who makes an application for as a foreign applicant or for an intercountry adoption to satisfy the court in certain ways. And one of them is that which is very important from what I heard Gemma say, that the country where they ordinarily reside and where they intend to reside with the child immediately after the making of the adoption order will respect and recognize the adoption order and grant resident status to the child. So unless the court has to satisfy itself that that is going to happen, because we have seen from Gemma's presentation, if that does not happen, then the child is the one who's going to suffer. So the court must satisfy itself to that extent that that is going to happen. And then that this applicant has been authorized and recommended as a person who is fit, including morally and financially, to adopt a foreign child. So it's not just a child, but to adopt a foreign child. I think Dr. Musoke touched that particular issue, by a competent government authority or a court of competent jurisdiction in the country where they intend to reside with the child immediately after the making of the adoption order. So these for me are key when it comes to foreign adoptions. There's been a lot of issues, foreign adoptions, intercountry adoptions, because there's a feeling that these are being denied. But if you look at the, or have been refused completely, but these have been put in place to protect the child. It is not about the adopter, but to protect the child from the difficulties that a child will face if they end up being stateless or having no home or having no parental care because of the challenges that come with the adoption by foreign or parents. So the court has to satisfy itself through that, our competent authority is the National Council on Social Services. It is recognized as the competent authority for purposes of the Hague Convention. So at least we have that in place. Now, I just want to illustrate a few of the things that the courts have been able to do to protect or safeguard the rights of children in the process of carrying out adoptions. For example, the issue of ensuring that the parties, the applicants, have complied with all the necessary requirements. I didn't want to repeat them because they are similar to the Ugandan ones, on what the parties must provide. If parties are married, there must be a marriage certificate. If they are they are financially able, then the bank records must be there. So in this case, in SM, a case was decided and the court refused the application because the parties did not provide a marriage certificate. There were no bank records. The Director of Student Services report, which confirmed the suitability of the parties, was not filed. And there was no certificate declaring the child free for adoption. And the biological mother was opposed to the adoption. You can see, you wonder how this matter came before the court, but the court was able to see that all these things were not there, and therefore the parties could not have been suitable to adopt this child. There was also another case in RSM where the court, upon review of all the applications, still found that there was no certificate declaring the child free for adoption and no written consent by the child's biological mother. And no legal guardian had been appointed. We know how that is important, that if there is no legal guardian, in the event that the parents, adoptive parents, are not there, then it means this child is left without someone to take care of them. And the court stated that the adoption of a child is a very serious undertaking and it cannot be dealt with in a casual manner. Then we had a case that looked at the moratorium that stopped the adoption of children by foreign applicants, LMG, where the court stated that that moratorium was unconstitutional. This is because in the first place, the moratorium was made before the law that we have currently. And then when the law was passed in 2022, the moratorium was carried forward into the law, saying that we could not allow inter-country adoptions. But the court was of the view that it is not in the interest of the child, in the best interest of children, that this is not allowed, that it is upon the state to put in place proper safeguards for those children who require to be adopted by persons other than the persons within the country. So that was declared unconstitutional, and the court proceeded to allow adoption of that child. Then there are also situations where we have adoption proceedings beginning early, when the child is young, and then the child becomes an adult before the adoption proceedings end. What does the court do? This is a child who has stayed with his parents for the longest time. Those are the only parents they require. So in a case that is called INRI JK adoption, the matter started in 2018. And by the time the matter was, at some point, it fell off the way. Sometimes when parties are not represented, you will find that they may not know what's going on with their matter and they may just leave it. Then one day they wake up and something is needed for this child. And they remember that, oh, we don't have the documents, we need to go back to court and get the documents. So in this particular case, the parties, you know, the young man needed an ID card, was already 19, and the adoption proceedings had been pending in court for almost 5 years. So the court did not ignore this, because in our act, there is a provision for extending parental responsibility in certain situations. So in this case, though it was an adoption cause and the child had already become an adult, the court extended parental responsibility. The child was recognized as the child of these parents, and the registrar of persons was directed to give him an identity card, so that, and then of course, so that he'll be able to complete his college. Then there are those I've already mentioned about kinship adoption, where parents, relatives can adopt their child, their relative, and in this other case, RTS, the court noted that the child who would require to be adopted was a nephew of the applicant, and the court allowed the adoption because the child had lived with the parents, with the relative, and only knew that family, and the family had accepted him as their child, and the adoption was allowed in the best interest of that child. So if you look at these cases, you will see that courts will make sure that the procedures that are required to be complied with by the adoptive parents or the applicants are complied with. It is the only way that we can protect the children who, as I indicated from the beginning, are children who are in need of care and protection, who need families that will protect them from whatever it is they are going through at the moment, and who have a right to retain their a right to be taken care of by their parents, and also a right to have a nationality and a name and all those things that go with any child in any family. The courts will go to those extents. And like you've seen in the case that I mentioned of the boy who had overgrown, that is not necessarily a case to say, now these ones can no longer be your parents. Courts have read into the into the Children's Act and been able to protect and safeguard the rights of that child. So what are there challenges? Of course, there are challenges, there are limitations, there are issues. For example, when a child is going into an institution, there are other agencies that are involved. For example, the police are required to investigate where this child came from and whether or not the report that is being made is true. Or if the child is lost, to find who the parents are. But more often than not, a report will be made to the police. They will receive the report and not carry out any investigation. And in many cases, the child's name may not be known. The child may be registered in the name of the person who brought them to the police or the person who received the child. The child is committed to a children's home in a different name, and the child may end up adopted and obtaining the name of the persons who adopted that child. So if this child was lost, for example, the parents may never be able to trace their child. If the child does not know their name or where they came from, depending on the age, they may not know. And that means that sometimes the adoption procedure process may actually be affected by that. If these people don't carry out the proper investigations or collect sufficient information, then it means that that child will never find their home. And if, like now, we've seen adopted children going back to find their homes or their relatives, they may never be able to find their relatives or find their homes. The other challenge is if the reports need to be done by children officers. And in my jurisdiction, there are not many, there are few. You can find there's one per county, and that sometimes leads to delays. And that, creates a problem in delaying the matters before they are heard. And of course, we also rely very much on the reports made by adoption agencies. And even when it comes to these people, how they are, like, how do I know the mental health, of this particular person who is before me asking to adopt a child? Because a lot of times that is not revealed, and I might not know whether they are okay. They may have the money, they may appear loving, but that person may have other issues that may not appear before the court. Then there's the issue of follow-up. A lot of times there are no follow-ups. In fact, in majority of cases, there are no follow-up procedures. What happens to this child after I make the order? Now, recently, since the new act, I've been making orders for follow-up by the the adoption agency social workers and the children officers, so that within the first quarter, depending on what the report says, I can be able to get a report through the deputy registrar of the process of this child, and also so that that family can get the support that they need. Sometimes we assume that the moment the adoption order is made, those people are okay. But I've come to the understanding that it's not always like that. The moment the order is made, even if they have been fostering the child, there's a big about turn. It's a big thing, and therefore they need psychosocial support. So I've made orders of late in the matters that I've done for psychosocial support by the children's services and the adoption agency to those families for at least a year after the adoption has been made. Adoption order has been made. So those are some of the challenges that I've seen when it comes to safeguarding the welfare of the children, even post adoption. Of course, the law now, we have a provision of the law that says if a child was lost and the parents find out, they can make an application for review of the adoption order. If they can demonstrate they had made a report, they had searched for this child, and they had not been able to trace the child, they can come to court, make an application, and the court can review the order or revoke the order depending on the circumstances, and make orders that are in the best interest of the child. So what is in the future for us? I think Gemma put it well. If we all sign my time is up?
Yeah, your time is up.
Okay. Just the last one. If we all maybe sign up on the intercountry, the Hague Conventions, it might help with cross-border adoptions so that we safeguard our children. Thank you very much.
Thank you very, very much, Justice Mateka. A round of applause to her. Thank you so much for those valuable judicial insights. Your presentation reminds us that adoption proceedings require careful judicial consideration to ensure that decisions genuinely serve the best interest of the child. Thank you so much, Justice Mateka. Thank you so much. So now we have our last speaker. The time is not on our side. We have our last speaker, Dr. Joseph Yav. He will explore more about adoption law reform in Africa, balancing child protection and sovereignty and international cooperation. So let me read his bio also, and then I'll give him the floor. So Dr. Joseph Yav is a distinguished legal scholar and practitioner specializing in family law, child protection, and adoption systems in Africa. He serves as a full professor of law at the University of Lubumbashi in Democratic Republic of Congo, and is the managing partner of Yav and Associates, a leading law firm with offices in Lubumbashi, Kinshasa, and Kolwezi. it's not easy. So Dr. Yav holds a doctorate of law from the University of Lubumbashi in 2007, and an LLM from the University of Pretoria, South Africa, in 2004. He is a human rights lawyer with extensive expertise in domestic and international adoption law, child welfare legislation, and transitional justice. So his work bridges academic excellency with practical legal advocacy, making him a respected voice on adoption law reform across the African continent. Dr. Yav, we are very, very honored to have you. Over to you, the floor is yours. Thank you so much.
Thank you very much, Nadej, for the floor. Allow me to start by saying thank you to ELS for this important discussion on adoption law in our region. As you clearly mentioned, I will tackle on how do we protect our most vulnerable children while respecting our sovereignty and working constructively with the international community. I will talk on 3 or 4 points quickly. First of all, the distinction while we are talking about adoption, the distinction because not all adoption systems are the same. Second, I will concur with Dr. Diana Musoke, lawyers as actors in child trafficking or adoption fraud. I will give a recent case. And then I will talk about the reform. Let me start by saying that after listening to all the speakers in their presentation, I think I realized that they are talking about one aspect or one form of adoption. But in our country, the Congo and probably Burundi and Rwanda, we have 2 systems. We have what we call, there is one system. There is what we call adoption simple. Simple adoption versus plenary adoption, where it applied in Europe. While I'm saying Europe, I'm referring probably especially to Belgium and France. So, as I said, we have in our region, in Congo, there is a difference. We have at one type of adoption, this is adoption simple. In this type of adoption, the child, so they under this system, the adopted children remained a legal member of the biological family. That's one. Even if that child enter the adoption family. So the child in our system, in Congo, Rwanda, probably in Burundi, yes, inter-country adoption in Congo, yes, it exists, but the child will remain the biological family child, but also will enter into the adoptive parent family. So this child will, that is more important. The adopted child will inherit from both families, from biological families and also for adoptive parents. Yes, because if a child is living with the adoptive parents, the adoptive parents have more power at parental charges and so on, more power than the biological families. But if there is any conflicting interest, and then in the best interest of the child, then things can change. In France and Belgium, the dominant model is what they call adoption plénière, plenary or full adoption. With this, that seems to be the system in most of your countries. As soon as the child has been adopted, the child becomes exclusively a member of the adoptive family, losing all legal connection with the biological parents. That is not the case. It's not the case in our region, in Congo. Why does this matter? Yes, because the distinction matters for child protection. With the adoption simple, with simple adoption, the simple adoption allows for ongoing oversight and connection. With the full adoption or adoption plénière, I think it creates a clean break. So there is the links with the biological family is almost removed from the picture. So understanding the difference will have an impact on how the adoption fraud is done. The second point, the child trafficking and fraud and adoption fraud. What this matter, I think the problem is, as Dr. Musoke Diana said, we lawyers, we are also part of the system, of the fraud system. Not only on the conflicting side, no. There is a scholar called David Smolin in his book, Intercultural Adoption as Child Trafficking, he argued that some intercountry adoption meets the legal definition of trafficking. And the World Vision lists illegal adoption as contributing factor to trafficking worldwide. So some people view international adoption as an act of compassion, like all of us, is an act of compassion. We want to rescue the child from poverty and so on. But others sees it in a form of trafficking, so buying children from the global south. So there is a confusion, and this confusion paralyzes both policymakers and families. There is a recent case in Belgium, involves a lawyer called Julienne Pemba. She's a trained lawyer of Congolese origin, living in Belgium. She said that she ran an orphanage in Kinshasa, where she promised Belgian families she would connect them with orphans, but the children were not orphans. Pemba's network trafficked 11 children from the biological families in DRC, gave them false identity, placed them with a suspected adoptive parent in Belgium. And recently, just last year, end of last year, the Liège Court of Appeal sentenced her to 14 years imprisonment for hostage taking, child trafficking, fraud, and forgery. So 11 children were stolen from their families, given fake identities, sold to well-meaning parents. That is a real case involved by a lawyer like us. So I concur with Dr. Musoke when she said that we as lawyers, we are actors. And the case of Julienne Pemba, she's not an outsider in the legal profession. She's one of us. She is or she was one of us. She's a trained jurist, someone who understood the law and used that knowledge to exploit it. We must acknowledge a hard truth. We as lawyers are part of this problem. Legal professionals, we draft documents, facilitate the procedure, and navigate the system that make adoption legitimate or fraudulent. So when lawyers participate in fraud, when we turn a blind eye to suspicious practices, when we prioritize fees over due diligence, the case of conflict of interest, we become complicit in trafficking. If we want to be part of the solution, and we must be, then our profession needs to hold itself to the highest ethical standard in adoption practice. This is not someone else's responsibility, it's ours. So on the third point, on the why adoption reform matters, let me say this. There are competing forces that make this issue so difficult. We face with three core tensions. First one, the children rights versus system failure. We all know that children have rights to grow up in family. They have right to identity and protection. There are instruments, laws that provide for that, including the Hague Convention on International Adoption. But inter-country adoption has been plagued by serious abuses. Child trafficking, as I said, forged documents, and payment to biological parents. This very system designed to help children has in some cases harmed them. Second, after the children rights versus system failure. Second is the sovereignty versus international cooperation. Family law sits at the core of national identity. African nations shaped by colonial history are more of us protective of the authority over the family matters. They view that the intercountry adoption is simply a new form of colonial extraction, this time of human being rather than natural resources. That perception is widely felt across the continent. Third is the urgency versus the slow path of reform. Yes, there are children who wait while we impose moratorium, while we build perfect system, but these children are real human beings with development window close with every passing years. My argument today is that we must navigate this tension through principled pragmatism, keeping the best interest of the child as our guiding star. On moratorium, thank Honorable Lady Justice for raising the point of moratorium, especially in Kenya. But I will cite 3 examples. The first one is in Congo, the Democratic Republic of Congo. First one, the DRC presents perhaps the most difficult adoption landscape in Africa. Since September 2013, the Ministry of Interior has stopped issuing exit permits for adopted children. So we can still go to court, you can still have a judgment for adoption, but you require the exit permit for the children to go out of the country. But since September 2013, this is no longer possible. So no Congolese child can legally live with adoptive parents. Why? There's cases like what I mentioned of Julien Pemba, the lawyer in Belgium. Children with living parents adopted under false pretense. The DRC is not party to the Hague Convention, but we have the law on the child protection of 2009. That law incorporates the Hague standards and punish child trafficking. In 2016, the family law was amended to strengthen that protection, but still on the ground, the National Council for Child, mandated by the law, is still not operational. So we have the laws, but we lack the institution to enforce them. And the moratorium is still in place since 2013. The Kenya, that is a different story. The court stepped in, even if there were issues, but in the case mentioned by the Honorable Lady Justice in LMJ, the High Court ruled that the moratorium was unconstitutional. The court reasoning was that blanket bans cannot override the need to assess each childbirth instance individually. So in the case of the DRC, I think there is need also of a ruling like that, because you can't just stop from September 2013 up to now without clear perspective. In Rwanda, I made some research. In Rwanda, the Rwanda shows that the moratorium can act actually fully suspension in 2010. That was lifted in 2017 after the strong new procedure were put in place. So there are ways of putting moratorium, but not blanket moratorium. What are the challenges? And then I will finish my recommendation. First of all, the challenge of the moratorium. Moratoria every year, if you look on moratoria or moratoria general per se, they create space for reform and prevent trafficking. But the moratorium needs to end at some stage, because a blanket moratorium hurts children. Second challenge is we have weak institutions. The welfare ministries are underfunded. Central authorities exist in some countries on paper, but can't function. There are shortage, especially of trained social workers, and the lawyer's case in Belgium is clearly the case where predators fill the vacuum. Third challenge is sovereignty and cooperation. The Hague Convention offers the tools that threaten national system rather than weaken them. So sovereignty concerns are legitimate, but Africa states have every right to control family law policy. So my pleading here is just to seek to African countries to be part of the Hague Convention, because in DRC we've amended our laws to be in line with the Hague Convention without being party. I think that on the ground is not helping. In conclusion, the states outside the convention, including the DRC, should pursue accession. The convention provides this that case like the lawyers Julian Pemba's show we are desperately needed. We have second recommendation, we have to make central authorities work with more staff trained and funded. Third, we have to invest in genuine subsidiarity. This means we have to spend really on family preservation, kinship care, and domestic adoption. Not just rhetoric, but the money must follow policy. Fourth, a time limit moratoria. The moratoria should have clear goal, defined endpoints, and accountability. An open-ended suspension harm children without guarantee reform. Finally, we have to strengthen domestic child protection. Long-term solutions require investment in family preservation, kinship care. And then my conclusion is to say that adoption law reform in Africa is part of our broader struggle to protect our most vulnerable citizens while maintaining control over matters of deep cultural importance. Thank you.
Thank you so much. Thank you so much, Dr. Yaw, for this kind of comprehensive analysis. Thank you so much. A round of applause to him, please. Yes. So now we've just reached at this segment of where we're going to have a Q&A session, but I can see we have many questions in the chat box, and the time is not on our side. I'm very sorry for that, but I just have one question out of curiosity, and my question goes to Gemma. I know in the UK it's allowed for the same-sex couple to adopt a child. So I'm just wondering, I know here in our region that topic is still controversial, but I'm just wondering, like, what are the rules, or what are there some restrictions when it comes to same-sex couple to adopt a child? Thank you.
Are you talking about domestically in England, or are you talking about adoptions that are coming from other jurisdictions?
Domestically, please.
We don't have any restrictions. Our domestic legislation allows for same-sex couples to adopt children. What I would say, though, in an international context, is that we are a signatory to the Vienna Convention, and when that comes to addressing adoption cases, our courts are required, if the child comes from another state, our courts are required under the Vienna Convention to notify the authorities in the other state. And in some cases where you've got a same-sex couple adopting a foreign national child who is in England and Wales, that child comes from a country where same-sex adoptions are unlawful or not prohibited, then we have to ask our judges for permission to perhaps not notify the foreign authorities in those circumstances, in order to protect the child and to protect the same-sex couple who are going through an adoption. And our case law has said that in those kinds of circumstances, if it was to protect the welfare of a child, then authorities would not need to be notified of that adoption. Does that answer your question?
Yes. Thank you so much. Thank you so much for elaborating on that. I truly appreciate. So here we have a question from Madalisto Chimwaza. Hopefully, I'm reading well your name. She asked, I think, Honorable Justice Mateka. She wrote that, my lady, would you kindly share the cases where assurance from the foreign jurisdiction was sought and court was satisfied that the adoption order, if made, would be recognized?
Thank you.
I think she will.
Okay, so the case I shared, the court actually, while declaring the moratorium unconstitutional, did not consider it to be intercountry. You know, it did not require to have that approval, so it proceeded to allow the adoption because there was a certain marriage between the parties that localized the adoption. So yes.
Oh, okay. We have another question for you from Mary Walbengo. She said, my lady, what prompts the court to order a family assistance order? What stands out during the process of the court, for the court?
Okay, I had tried to answer it. I said that when one of the things I found out when hearing adoption matters is I asked the social worker from the adoption agency whether post the adoption proceedings there was any support for the family. She said no. The moment they were done with the adoption, that was the end of the matter. Then I asked the children officer who was in court whether there's any follow-ups that they do after the adoption order has been made, and the person who was in court said no. And there's a provision in the law that says that should be available. And I had interacted with some families, adoptive families, and I found that usually there is need for post-adoption support. So I made it part of my order that other than the order for adoption, that there ought to be support from the social worker and the Department of Children's Services for the adoption family. So it's not like there's something that will prompt it, but the families that speak to when the matter is proceeding in court would indicate that they would actually appreciate support after the order has been made. Yeah.
Thank you so much, Our Lady Justice Mateka. And at this juncture, I think we are remaining with 4 minutes. I'd love to thank each one of you. A special thank you to our speakers and also to our conveners, IFA and also ELS Family Law Committee. Thank you so much, participants. Thank you so much for your contribution. Thank you so much for your time. We truly appreciate it. I always say that even though I work with the ELS Secretariat, I'm always impressed by the way ELS is able to gather lawyers from different jurisdictions, from different law systems, common law systems, civil law systems, hybrid, and ELS gathers us together in the same room so that we can share experiences, practice, everything. So a special thank you to ELS for hosting us. And I think for me, that's it. I can see questions are still coming, but we hope you. I have you can text. You can send those questions to ELS email. You will be responded. So thank you so much. Over to you, Gabriel. Thank you, Rachel. Thank you, Patricia, Gemma, Honorable Mateka, Diana, Dr. Yarv, and everyone here. Thank you so much. We truly appreciate it. Over to you, Gabriel Chai.
Wow, thank you so much, Nadej. What a way to bring it up to a very wonderful close. It's been quite captivating, insightful, and indeed we've been taking down notes. Special thanks to you, IFL, for making this possible and bringing your expertise. Thank you, Gemma. Thank you, Rachel. Thank you, Patricia, for putting this together. Special thanks to your distinguished panelists, Dr. Yav, the Honorable Lady Justice, and Senior Counsel Diana Harriet Mutoke, who unfortunately dropped off a little earlier on. Thank you, friends, for these wonderful questions. Like Nadeja said, please keep those questions coming. Keep that conversation ongoing. And in fact, let's take this conversation a notch higher, probably on Twitter. Let's debate, let's share ideas. You can even write to us at info@elosociety.org. We'll be more than happy to respond to those questions and share them with our esteemed panel. Please note that a recording of this session will be shared with you at the tail end of this session so that you can, revisit some of these very important items of discussion that have been outlined here. Now, please, as mentioned, in the month of April, we have another very interesting subject that we'll be discussing as a family law committee, and that's the subject of surrogacy and assisted reproductive ARTs. So please be on the lookout for that session. It will be happening in the month of April. That brings us to the close of this webinar. Please be on the lookout for more of our sessions next week. So next week, friends, we'll be discussing another very interesting subject, and that is along the lines of strategic extractive contracts. And we'll be discussing how do we drive sustainable development and long-term value in East Africa. Please join an esteemed panel of senior counsel and experts that have cut out a niche in this sector. And we'll also be talking tax on Thursday with navigating tax trends that are sweeping across the region this year. So from us to you, we wish you a very lovely afternoon. Eid Mubarak, my friends will be enjoying tomorrow. Please feel free to invite us for pilau. I'm readily available. So please hit my DM and I will be at your doorstep. Enjoy the day until we speak again. Goodbye.